A jury awarded over $4 million to Heidi Jordan, who slipped in water in an aisle and injured herself at a Publix store in Leesburg, Florida. She suffered herniated discs and she had to undergo cervical fusion. Publix admitted negligence and the court ruled in her favor. This is apparently the largest verdict ever in Lake County for a slip and fall case. And here to discuss it is Morgan & Morgan's Woody Woodard. Woody, good to have you with us.
Thanks, Carl. Glad to be here.
That led to this case apparently happened way back in 2020. Tell us what happened.
This is a sort of standard everyday kind of thing. People, Miss Jordan was at the Publix. It was about 7:45 in the morning. She was getting some food to prepare a breakfast for some friends. And as she was kind of pushing her cart through the produce section, she comes around the corner of one of the bunkers that has both refrigerated food and dry food. And she slips on liquid that had been, underneath the bunker, kind of had been there for a while. And so she falls down and really smashes her right arm into the shelving and then falls all the way down onto her rear. And, it gets pretty banged up. She actually ends up with a very large bruise on her right arm that develops over the next day or two to the size of a softball. And that's how this started for Miss Jordan all the way back in August of 2021.
So apparently the defense's highest settlement offer was $200,000. Why was it so easy for your team to walk away from that offer?
Well, they didn't offer the $200,000 until maybe a month or two before trial. Previously, we had tried to resolve the case for, I think somewhere a little bit north of that neighborhood, but that was before she had the surgery. And once she had the surgery to her neck, which didn't occur until January of 2024, there really wasn't any way that we could even get down to that number. They were basically offering her less than her medical bills already were. So it wasn't something that Ms. Jordan was interested in taking. Had they offered some amount of money that was similar to that at the very beginning of the case, then that might have been something that she would be interested in. But after all of the years of physical therapy and pain management injections, I don't think they ever offered more than $50,000 until after she had her cervical fusion. So it just wasn't something that Miss Jordan felt that was being offered in good faith.
Tell us a little bit more about Miss Jordan, your client. What was her life like before the accident?
All these cases are very interesting. You really get to know people. You get to know your clients, and you get to sort of understand who they are. Her story is unique, just like everyone else's. She had recently moved to Florida from California. She was sort of starting her life over again after going through a difficult divorce with her husband. And she was moving in with an aunt, and that aunt unfortunately passed away. So she really didn't have a lot of family. And then this incident happened and really put her in a difficult position because of the injuries she sustained. She had to reach out to her friends who she had recently made living in Leesburg. And then and ultimately, I think she moves to Vero Beach or Ormond Beach. And so she really became dependent on, friends outside of her family to help her with her, everyday life. And it changed things quite dramatically for her. The incident also, it did not help her get out on the dating scene, and so she really just felt like her entire life kind of collapsed into this room full of pain that she was living in. Very difficult situation. And, I really think that Heidi is a very strong person for being able to go through that.
Now, Morgan & Morgan attorneys have really deep insight into major corporations like Publix, like Walmart, and their safety protocols and their lapses in safety. This allows you to quickly assess liability, usually in cases like this. Can you talk about the sort of resources that Morgan & Morgan is able to bring to bear in premises cases of this nature?
Right. So, we have a lot of cases against, Publix and against some of these big box stores. I came to Morgan & Morgan about 5 years ago from the defense bar, and we started up a division that focuses solely on premises liability cases. And so all of my cases, or I should say the vast majority of them, are uniquely focused on this type of law. And the department that I'm in and the lawyers that I work with, we all focus our practice in this area. It makes it easier for us to handle because we're used to dealing with the types of lawyers who show up for Publix and the objections and things that they raise, the sort of roadblocks that they try to put up to prevent us from getting some of the discovery that we need in these types of cases. For example, Publix often tries to prevent anyone from seeing the video of the fall until after the plaintiff is deposed in the litigation. And so we always are fighting with them over their policies and procedures when we can get the video and things like that. Ultimately, the video in this case, clearly showed that she did nothing wrong. And it was very helpful for the jury to see her go down and fall, but also see, the store manager walking through the area about 7 minutes before she fell, completely, disregarding the spill on the floor.
Right. And now, apparently, Publix actually admitted that they were liable like the Friday before the trial started on a Monday. What factors then did the whole case begin to hinge on at that point?
At that point, what they were trying to do was build credibility with the jury, saying, listen, we caused this fall, but we just don't think these injuries are related. They were trying to kind of take the bite out of us being able to talk about, oh, here's the manager walking by, not looking. Here's all the store associates walking by, not looking. And so the case really at that point turned on damages and causation. And so Publix's main argument in this trial was that Ms. Jordan did not complain of neck pain in the initial visits, 2 or 3 visits after the fall. What she was primarily complaining of was pain to her, the giant softball-sized bruise on her right arm. But when we really focused in on those complaints and really got a close reading of the medical records, she was also complaining of numbness and tingling in her fingers and in her hands and down her leg into her toes. And so, the challenge that we had at trial was to educate the jury that those types of findings, those, complaints and objective examinations from the physicians were indications that she had suffered an injury in her neck. Because when you pinch a nerve in your neck, it's not going to hurt really much in your neck as much as it's going to turn off the nerve and shoot all these numbness and tingling pain down your arms. And so once we were able to sort of educate the jury about those complaints and show them that, yes, those complaints are there, even though she didn't say my neck hurts, she said my fingers and toes are numb. And then about 16 days later, she sees a specialist. And the specialist says, whoa, you've got these complaints. We need to do MRIs. We get the MRIs. And of course, the MRIs show that she has herniated discs in her neck and in her low back causing these things. And so that's what the case ultimately turned on.
What considerations did you then have during the jury selection process?
So this is an interesting venue. It's a very conservative venue in Florida. Lake County is a small town. And so part of the process that we were looking at the trial was, what are the types of jurors that we want to be on the case and those that we want to sort of avoid. It's a very nuanced kind of thing. And ultimately, I think we picked a pretty good jury of people her age, men and women. Different minorities were included, and to give her really a jury of her peers, and also just to try to sniff out those individuals who might be less receptive to the type of non-economic damages that she was claiming. A large part of the jury consideration, jury selection consideration is, do people believe that you can recover even money damages for these types of things beyond medical bills? Because that's a large part of the case. It's not just about how much money it's going to cost to pay her doctors back, but it's also about the measure of damages that is necessary to put her in the same position that she was in before she fell, before she was injured by Publix's negligence. And talking about that in a very abstract way to kind of get people understanding that this is not just a case about, doctor treatment. It's also a case about what Heidi Jordan had to go through in the past and will continue to go through in the future.
Right. This case was worked by Rocky Wilkins and Michael Patrick and yourself. How did the three of you prepare the arguments that you thought opposing counsel were going to bring?
I've worked on this case since the beginning for the last 4 years or so. And what we do as a firm is when we go to trial, we bring in additional attorneys to kind of help at the end, help trial. So Rocky joined about a month before trial, Michael Patrick about maybe 2 weeks before, just to kind of get hands-on and get a lot of experience and help, because there's a lot of moving parts. And so once we really develop the trial team, myself as the lead attorney kind of sits down with everybody and we kind of go through what we want to do with each witness, which witnesses we want to call, what facts and things that we want to highlight to the jury. And we want to make sure that it's educational as well, because when you have a lot of experts come in, you want to make sure that one expert is talking about, one thing and not every expert talking about the same thing. And so what we do is we draw up an order of proof and we talk about what each witness we want from them and then what we want to get out of the defense witnesses on cross-examination. And so we kind of build our trial that way.
How then did you approach closing arguments?
The way I do it, and each attorney does things differently, but during the course of the trial, I like to take notes on a notepad, a big notepad in front of the jury. And so with each witness that we have on the stand, I'll write some things down, things that are good for us, things that are bad for us. And then I can go back and I can talk about them and why, what evidence leads to different conclusions and why people are bringing up this or why people are bringing up that. And so it's helpful for the jury because they see me write it down in front of the witness. They take their own notes. And then in closing, when I'm talking about the case in summation, I'm flipping through the notes and it's going to help them remember, oh yeah, the witness said that. It's in my notes, it's in his notes. But also, one of the main things that we did in closing in this case was helping the jury understand that this case is really not about the money. It's not about Publix. It's about the harm that was caused to Miss Jordan, and really focusing on that because that's the meat and potatoes of why we're there. We're not here to just kind of pay her medical bills. We're here to make her whole and helping them understand that. And also just addressing some of the positions that, Publix took in the case that all of the witnesses at some point ended up refuting. So at the end of the day, they didn't have a lot of strong arguments to talk about because we were so prepared with our witnesses through the course of the trial to refute each and every one of those points.
So the verdict really does underscore that any business has a legal obligation to maintain safe premises for their customers. But what did you learn from the case? What was the takeaway for you personally?
I think this case was really one that highlights the fact that we shouldn't be afraid to try cases, especially in conservative venues. A lot of people think, oh, Lake County, Florida, I'm never going to, a jury is never going to award me anything, or they're going to be very defense oriented. the more experienced trial attorneys you have, you can sort of deal with those nuances in the venue and get favorable results. I'll add that we tried this case in late June of 2024. In early June of 2024, I was in Georgia on another trial in another conservative venue, and we ultimately got another 7-figure verdict for our clients on a similar issue. I think that case was against Walmart. And so just having the guts to go in and try a jury case and not worry about what other people think about the venue or how that's going to affect the verdict is what really has been changing my mind on these cases.
Super. Woody, thanks for discussing what is really a groundbreaking win with us. Thank you.
Absolutely, Carl.